my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and China's Personal Information Protection Law, PIPL. So China has created this data protection law that goes into effect on November the 1st, related to the data of individuals, especially in a business to consumer framework. So people try to compare and contrast China's data protection law to things like GDPR. I think it's similar to GDPR in that it's trying to create a more comprehensive framework around how businesses handle data of consumers and gives them more clarity about how China wants data of consumers handled by businesses, either the businesses that handle data of anyone in China. So it is comprehensive like the GDPR. It's more consumer focus as opposed to human focus like the GDPR. It has 7 legal bases for data use and data transfer, as opposed to the GDPR, which has 6. The GDPR has a high fine of 4% of a company's annual worldwide turnover, and this has a 5% fine. Some of the big differences, the way that China is sort of doing things, they mention their national security as a big factor in terms of how they diverge from a person's individual right to the rights of China, right, as a government. Also, one significant difference that this law has between the GDPR is that a person's privacy right can go beyond the grave. So in GDPR, the GDPR is a cradle to grave privacy law. So when someone is deceased, they can no longer access, or they can no longer, their privacy rights under GDPR no longer exist. So in the Chinese privacy law, if someone is deceased, maybe a relative or someone can actually still control the rights to their information even after they pass away. A couple of other things that China has in this law. Some of these things really shouldn't be all that surprising. I think the thing that China has done is create more clarity. Because if you look back over the years at some of the actions that China has taken against tech companies, it's pretty evident they've just codified this in their laws. So some of the things are, harsh penalties and harsh and swift penalties, where, for example, China may decide they want to shut down certain apps. We saw with the TikTok incident with the U.S., they sort of put on export control, so there's kind of a retaliation part in there. Data localization is really big. A lot of companies that were afraid to do business in China assume that everything had to stay in China, and to some extent that's somewhat true. But this data privacy or data protection law tells in what circumstances that data can be transferred out of the country. And then also there may be fines for executives. So in addition to fines for companies, executives can also be fined. So we're seeing that also in places like India and Australia, where they're trying to create more stringent safeguards and governance and more responsibility for companies, even for executives, and how they're handling data. So this is really interesting. I think a lot of people, big companies that do manufacturing in China know and understand a lot of these things already, but I think codifying it into a law gives more information that for people who want to do business in China. So China, as we know, is the second largest economy in the world. They have I think last time I checked, almost 1 billion people online. A lot of our manufacturing in the world happens in China, so this is a big deal. And so we'll see how all this plays out over time, and how businesses handle consumer data for people in China. That's it. Thank you.